Please, Your Lordship. Your Lordship, I beg to mention item number 5, Your Lordship.
Number 5.
Yes, Your Lordship. The learned counsel must appear when is out of station, Your Lordship. I pray for 1 week's time, Your Lordship.
This is just for filing of a written argument, isn't it?
Written argument. In fact, I'll just make a small oral submission and also file the written argument. Only on 2 or 3 points.
How long?
1 week's time, Your Lordship.
On pre-made by the appellant. This is matter up to 1 week.
Similar prayer on item number 10, Your Lordship. Your Lordship, we have already filed the affidavit. Let this matter become
I have received the affidavit, my lord, which they have, my lordship has allowed them to file an affidavit. They brought some, one notification to record, my lord. So, my lord, I will also have to reply to that. However, my friend is not available today, so
Oh, you have received?
I have received, my lord.
So you
I have,
reply to that.
my lord.
So 1 week.
2 weeks' time, Your Lordship.
2 weeks time, my lord.
They wanted to ask me, why do you have to ask?
2 weeks time, my lord.
On pre-made by the parties, this is matter up to 2 weeks.
Similar prayer on item number 13, Your Lordship. It's our joint request, Your Lordship. And for the respondent number 3 to 5, Your Lordship.
Your Lordship, similar prayer for item number 13, you know. Lordship, item number 13.
So how long?
2 weeks.
On pre-made by the parties, this is matter up to 2 weeks.
I do oblige.
May it please Your Lordship, I beg to mention item number 8, Your Lordship. I'm appearing on behalf of the petitioner, my lord.
2020 matter.
Yes, Your Lordship.
So why is taking you so long?
Your Lordship, here they've been continuously seeking for time also, Your Lordship.
Dear the petitioner, what is the case about?
Your Lordship, the case is about the resignation of the petitioner to the post of additional subdivisional school.
Oh, that.
Relegation. Yes, Your Lordship.
How long?
For 2 weeks, Your Lordship.
Why 2 weeks?
As the conducting counsel is quite not well, Your Lordship.
On pre-made by the petitioner, not objected to by respondent. This is matter up to 2 weeks.
Obliged, Your Lordship.
Similar prayer for item number 15 as well, Your Lordship. I'm appearing on behalf of the respondent in this matter.
Lordship, appear on behalf of the petitioner.
Yes. Any objection?
This will be last chance. They have asked time, I think, four times already.
You have for state.
I know, Your Lordship. Yes, Your Lordship.
On pre-made by the respondent. How many respondents are here?
So respondent, Your Lordship. So respondent.
Pre-made by the respondent. Not objected to by the petitioner. This is matter up to 2 weeks. Be sure this matter can be disposed of in one sitting.
Yes, Lordship. Much obliged, Lordship.
May it please Your Lordship, apologies, Lordship.
Tell me.
Lordship, I beg to make a mention of item 7.
So to
I'm the respondent here, Lordship. Sole respondent.
2020 matter. Who's for the petitioner?
I'm a petitioner.
Yes. Any objection?
Time and again, It will be positive in the next date, my lord.
Lordship.
That I will say. You will say, you will commit, but then next time you come, same excuse.
Exactly, my lord.
But you see, ensure, you see, the request of this court is as far as these old matters are concerned, try to make an effort, endeavor to at least let the matter be over. Like I used to say,
True.
what comes next, nobody knows. At least at this stage, let us get it over and done with.
Lordship.
How long?
Lordship, after puja holidays, Lordship.
It will be positively after vacation, my lord.
On plea made by the respondent, not objected to by petitioner. This is not up to the puja vacation.
Highly grateful, Lordship.
Daily cost list item number 1.
May I please, Lordship?
Yes.
Lordship, I'm moving bail for this accused person, Kim Nicole Kongse. Lordship, on the previous occasion also, this we have moved the application for this accused person before this honorable court. Lordship was pleased to reject the application. Now, in this present application, we are moving bail on the ground that the accused person is not keeping good health. Her health condition has deteriorated, and moreover, like she's suffering from so many ailments, and apart from that, she has got her hand has been imputed, and which is required to be removed. And on many occasions, she was taken to the civil hospital as well as Nigrim hospital for treatment, and they have also suggested to remove the iron bar which has been imputed in her hand, and which is an immediate requirement for the purpose of maintaining her health. Now, though the Nigrim hospital has to say that operation can be done in Nigrim hospital, but she's suffering from so many other ailments like diabetes or any other problem, and she has been referred so many times. And during the time of her treatment, her family members are required to take care of her, and now she has been taking treatment at this Silchar in one hospital in Silchar, wherein she prefer to go there and take the treatment where she has been taking the treatment. And moreover, apart from her preference, since it is a major operation, the family members are required for the purpose of taking care of her. And then now for family members are all staying that side in Manipur, and it is difficult for them to come here to take care of her during the time of operation. So it'll be more convenient for the accused person, for the health of the accused person also, to be taken care by the family members during the time of her operations or medical treatment. It is very necessary that family members are there. Now, at this stage, Your Lordship, I am asking for the bail to either to grant her for regular bail in the instant case, or either temporary, so that she can take an effective medical treatment which is necessary. And time to time, wherein she has been also referred that her health condition is deteriorating day by day, and it has been referred that she required an urgent immediate medical treatment. So in the case, of course, like no contraband item was found from her possession, which was neither any link to anything to link her to the alleged offence. No materials on record is available. That is on merit. But at this stage, apart from that, she need a urgent medical treatment. So I am coming before this honorable court to kindly grant bail to this accused person, so that she can take an effective medical treatment, so that it will save her life, Your Honor, because her condition is very bad. Her life is at risk. For that reason, I'm before this honorable court, Your Lordship.
Yes, Mr.
May it please Your Lordship. Lordship, in fact, earlier the bail application has been rejected by this court. If Your Lordship kindly come to page 10, Annexure 11, Your Lord, Annexure 2, Your Lordship, Annexure 2. Lordship will kindly come to page 17. page 17, para 21. That bail, Your Lordship, has been rejected, Your Lordship, by this court. Lordship, after scanning the authorities, Your Lordship, rendered by the Honorable Supreme Court, Your Lordship, this court was pleased to come to a finding that this is not a fit case for grant of bail, Your Lordship.
Yes, at the relevant point of time.
Yes, Your Lordship. Then I kindly come to page 18, Your Lordship. Page 18, that is the medical, because the bail, now this bail has been filed on medical ground, Your Lordship. Kindly see, Your Lordship. Kindly see, this is from NACRIM, Your Lordship. The Lordship, in my humble and respectful submission, Your Lordship, the these are not, this is not a life-threatening, Your Lordship. Kindly see, Your Lordship, severe pain over arm, left arm with implant, Lordship, very difficult to say.
Plan inside.
Yes, Your Lordship. Then visual
hallucination.
Lordship, very difficult to, inability to sleep. Then, Lordship, what are the advice, Lordship? Kindly turn to the next page.
Yes.
Lordship, there is, these are the physics,
Psychiatry, OPD.
Safety, OPD. This is for meant for outpatient department, Your Lordship. See? It's not so life-threatening, Your Lordship. So as to say, Your Lordship. And then, Lordship, kindly come to page 20 next. Annex of 4, Your Lordship. Implant in weight operated in June 2014. Pain. Then patient not willing to undergo implant removal in NACRIM Shillong. Patient wants to consult with Dr. Kokoy in Bali Hostel Silchar. But she refused, Your Lordship, the treatment provided by the by NACRIM. Then, Lordship, kindly see to page next page 21, Your Lordship. It's this is normal, Your Lordship. This is a cough and fever, sneezing. These are normal, Your Lordship.
What is the stage of the case?
Now is at the stage of evidence, Your Lordship.
Evidence.
Evidence, yes, Lordship.
How many witnesses?
One witness has been examined. No, in this one, no? Yes.
How many left?
Out of how many witnesses? 15 witnesses. 9 witnesses are there, Lordship. So, in this particular case, so one witness has been examined in this case. The second one, no witness has been examined. She has been charged under two cases on the same day or subsequently when she was previously on the last date when we moved the bail application. We have stated before this Lordship also that when she was coming to appear in Shillong court, that time only she was arrested, shown to have arrested in these cases. So in this case, 1 out of 9 witnesses, 1 witness has been examined, the complainant. But here, Lordship, at this point, if my senior has finished.
So, Lordship, my humble and respectful submission, Your Lordship. Can you see there? It is not the case that medical treatment has been refused or has not been provided by the state while she is in custody. That is not the case, Your Lordship. Lordship, can you see page 21?
See, Mr. Shurai.
Lordship, yes.
When it comes to issue of sickness or ailment, of course, number one, the court will just go on the medical evidence that is there or materials, and cannot see at prima facie cannot come to an opinion whether the sickness or ailment complained of is serious or not. That is not for the court to decide or no at this point of time. Number two, it just struck my mind is she was advised to to complete the procedure at NACRIMS, but she wanted to go to the certain hospital at Silchar. On that point, if you have any authority to support your case, whether that can be allowed or not, preference of a of a UTP for medical treatment,
Lordship,
whether that can be allowed or not, or is it to be imposed by the authorities that since you are a detainees, or since you are an inmate or a under trial prisoner, you are to follow whatever we say. You understand? So those are the question that that lingers in the mind of the court, keeping in mind the overall health of. But if her health deteriorates because of not being able to get proper medical attention, then responsibility has to be fixed. But on the other hand, if it is a normal procedure and this is what is done, then there's no way out. You have to follow that. In any case, the bottom line is you are getting treatment. Either here or there, you are getting treatment. So to that extent, I don't think you're paid. Except if many times this court has observed, if it is specialized treatment that is required to be done elsewhere, which either civil hospital or negrims cannot do, then there are some departments, like for instance perhaps cardio or neuro, which could not be done anywhere. So you could have done it in Guwahati or somewhere else. That maybe. But this is only for removal of the implant.
Yes,
So
Lordship.
that procedure, if it can be done in negrims, then
removal of the implants, so like it's not a simple kind of one simple injury that a person will be stitches or something like that, but complications is there, and then during this time of treatment, because he is having so much of complications with other ailments and all also, so it's a major operation, so she needs and require the
who are we to say that
I'm not a medical expert, Your Lordship.
Who are we to say that it cannot be done at negrims or civil hospital or any government hospital in the state? We are not to say that.
And okay, apart from the Lordship, either temporary or even temporary also for the purpose of treatment, temporary bail also I'm asking at this stage, so that she will be able to get a proper treatment. At the same time, with the she will be help and care of the family members will also be received by her during the time when she's taking the treatment. So Lordship, if your Lordship please please to call for the report also, Your Lordship. Your Lordship, from the medical
report
also,
I think is
from the jail authority, all the medical report, whatever.
These reports you have filed.
These also I filed, and apart from this, if they have any detailed report, because she has been sent continuously for medical treatment, and they have been seeing that her condition is not really good. So I humbly pray Lordship may please to call for the report from the jail authority, from the jail authority doctor, so that they can give a concrete finding report of her medical status, Your Lordship.
See, this is the report. I think the last page of your petition, the date of reporting is 1/9/23. So about a month or so have passed by. Within this month, the previous month rather,
yes,
was she, has she undergone any, treatment? Has any recommendation been made or opinion given by the doctors?
Lordship, I humbly pray Lordship may please to call for the report, so that all status of our medical report can be.
And in the meantime, try to find out the authority on the point that I have, inquired.
There are medical report, medical prescription are here in the petition itself, Your Lordship. Calling for the report, Your Lordship.
No, but we have to see. Like I said, if we go by these papers, the latest report was 1/9, so that was in September. You go look at page 22.
Page
22, the last page of the petition. Look at the date of reporting.
Yes, 19/23, Your Lordship.
Yes,
These are it's very difficult to read this.
So 1/9, so 1 month have passed.
RX and advice. Very difficult, Your Lordship. I can't read.
Fine. Then let's go to last query.
Lordship, this is Lordship. Kindly see a patient chief complaint pain. Pain only, Your Lordship.
Pain.
Yes, Your Lordship.
The pain is because of that. Yes, Lordship.
Lordship, and the fact remains that she refused treatment in Nekrim. Nekrim, Your Lordship, is a specialized institution, Your Lordship. They have all the facilities, Your Lordship.
That is why, you see, the query of this court at the first instance was whether in such a circumstances as this, a UTP, whether she can prefer.
Lordship, I got the point here, Lordship. Whether she can dictate the one hostel that yes, no, I don't want to get treatment here. I should go to some other hostel.
You can put it that way anyway.
Lordship, yes.
Just try to.
That is what, Your Lordship. The medical prescription from Nekrim is very clear, Your Lordship, that she dictates, Your Lordship. She dictates the Nekrim. I don't want the treatment here. I want somewhere else. It's very clear, Your Lordship.
We'll see. You find out some authority on that. Is she direct counsel for the petitioner? Who has preferred this application for bail under section 439 CRPC on behalf of the accused person, Srimati Kim Nekol Kong Sai, in connection with what is the
Period PS case number 65.
The case has been
NDPS.
what's the register? What's the regular case now?
NDPS case number.
You have not indicated.
NDPS 9 of criminal NDPS case number 9 of 2020.
NDPS case number 9 of 2022 or 23.
23, Your Lordship. Come here.
Pending before the special judge NDPS. Clear.
Clear yet, yes, 22.
Clear.
9 of 2022.
No. Maybe.
The Learner Council has submitted that.
No, criminal 11. Lordship, criminal
cases number.
Criminal NDPS, criminal NDPS
11 of 2022 because I moved 2,
Lordship.
that's why. Sorry, Lordship. 11 time.
11, Your Lordship, not 9. 11 of 2022.
11 mo. Unum to. The last line. Clear. The 2023.
22.
22.
Yes, Lordship.
22. The only ground urged by the Learner Council for the petitioner in this instant application is that the accused person is suffering from a number of ailments, more particularly having, do you call it an implant or what do you call it?
Implant, yes.
Implant, Your Lordship.
Implant,
As per that Nekrim report,
Having a
implant, Your Lordship.
an implant on where
Left arm.
on her left arm,
Side 2, what is that? Side 2.
which requires urgent medical treatment and considering the fact that the accused person had been treated for the same at the, where is that, a hospital? Silchar?
Valley Hospital, Lordship.
Valley
Valley
Hospital?
Hospital, Silchar.
Valley Hospital, Silchar, in the state of Assam. Though the authorities concerned had advised that the said procedure be done at the Negrims, the petitioner, the accused would prefer that the said procedure be done at the said Valley Hospital, Silchar. At this stage, the Learned Council had prayed for regular bail to allow the accused person to get proper treatment, accompanied by her relatives, or in the alternative, to be allowed to go on interim bail for the purpose of undergoing the said treatment. At this stage, however, the Learned Council for the petitioner has submitted that the latest medical report may be sought for from the authorities concerned to enable this court to apply its mind accordingly. On consideration of the pyramid,
You can do in civil also.
the District Prison and Correctional Home Authorities at Joy
Lordship.
at Joy are directed to file the latest medical status report of the said accused person and to place the same directed to file before this court on the next date fix. Today is
This 9.
so how soon can you do it?
Let it be on 18 then, Your Lordship. 18 or 19.
18 will be too long. 16, 1 week.
16 or 7. Let it be on 17, Your Lordship. 17.
Place this matter on 17th.
Second one also same order.
Same accused person.
Same accused?
Yes, Your Lordship.
So same order.
But only the criminal NDPS case portion, that one will be 9th of 2022. That 11 will be 9.
Okay, 9. But the complaint is same.
Pardon, Lordship?
Complaint is the same.
No, different.
No, I
Period
mean,
PS case
no,
number
no,
also
her
different.
complaint is
Yes, same,
is
Lordship.
about the
The plea
fitness.
is, yes, Lordship.
Fine. Thank you.
Pabla, Your Lordship.
Much obliged.
Item number 3.
Yes, miss.
Your Lordship, on the last occasion, we have sent a notice, Your Lordship, to respondent 7, 8, and 9, Your Lordship.
I'm appearing for the state respondents.
Any report?
I think it's as per the postal receipt has been received, Your Honor. It has been delivered, Your Honor.
Have you filed your
We will file on the next date, Your Lordship, for the affidavit of service.
Legal counsel for the petitioner has submitted that the notice issued upon the respondents 7, 8 and 9
Yes, Your Lordship.
has been received as per the information received from the post office. It is, however, submitted that the affidavit of service may be allowed to be filed in this regard.
Lordship, in this matter, I have not received the copy of the review petition copy.
Please do
Let
it.
them give.
We'll serve.
Mr. Ishkarmi, the additional senior GA, appearing for these, has appeared for the state respondent. State respondent.
Respondent, yes, copy. One to six, Lordship. 1 to 6.
1 to
1 to 6.
6.
Yes.
And okay, that is only 7, 8 and 9.
Yes, Your Lordship.
1 to 6, no?
Yes.
On previous, this is matter to 1 week.
Okay. Much obey, Your Lordship.
Item number 4.
Your Lordships, on the last occasion, this is a challenge against the order of the Meghalaya Board of Revenue.
Okay.
May I pray if the matter can come up after 2 weeks, my lord? I'm not fully prepared in the matter, my lord.
2015.
Yes, my lord. I have not even prepared thoroughly the case.
2 weeks.
They'll have to come after the puja vacations, village.
For a person of your caliber and experience, why 2 weeks?
So sorry, absolutely sorry, my lord. I did not expect that.
No, let's fix. Can we do it on 19th?
Yes,
Village, I will have some difficulty, village.
Oh.
20th, the pujas are starting, village.
After puja,
just some family commitments. That's the only
do it after puja, my lord.
Mr. S. N. Gupta, GA appearing for the respondent, state respondent, has submitted that due to personal difficulty, he is not prepared to argue this matter today and has sought for accommodation thereof. On submission made with the parties, this is matter after vacation.
Grateful. Highly pledged.
Item number 9.
Well, please, Your Lordship. Lordship, here the government is supposed to seek instruction, my lord, in respect of a letter.
I have sought instructions, my lord.
What is this case about?
My lord, this is regarding, my lord, that school matter, my lord, where he was appointed by the managing committee. On the first round of litigation, my lord, he had approached his honorable court with a prayer that he should be regularized, he should be considered, his service should be considered under the district council.
Oh.
He was regularized, my lord.
No.
We are before this honorable court so that we may fall under the purview of the old pension scheme, my lord.
Oh, pension scheme.
Lordship. So last occasion they issued a letter, my lord, saying that I may be submitted GPF with a new GPF
that was
format,
on
my
the
lord.
request of the petitioner, it was forwarded, my lord. However, the fact remains, my lord, he is only entitled under the new pension scheme, my lord, not under the old pension scheme.
Oh, yes. Now, so the issue is with the period of regularization.
Yes, my lord.
Whether that would, come into effect as soon as he was
Regularized or not.
or with retrospective.
Lordship, effect.
So that is the.
That is the issue, my lord.
So please.
Lordship. Here, my lord, the petitioner actually was appointed way back in the year 1992, my lord.
Yes.
That is Annexure 1. And it was under the
Annexure 1 is
page 16, my lord.
Yes.
The school was under the control of the district council back then, my lord.
Yes. Petitioner appointed.
Lordship. This was under the control of the district council back then, my lord, 1992. In pursuance of an act, my lord, taking over the district council Lower Primary School Act of 1993, my lord.
Yes.
The schools which were under the control of the district council were taken over by the government, my lord.
When was it taken over by the government?
It came into effect in the year 1994, my lord.
Where's the
2nd June of 1994.
Where is the notification?
We have not enclosed the notification, my lord, but my lord, this is the notification. Second June of 1994. It came into effect in the year 2nd June of 1994, my lord.
Yes.
Lordship. So thereafter, my lord,
yes,
similar situated person were regularized, my lord, way back in the year 2012.
Yes.
Lordship can kindly come to Annexure 16, page 64, my lord. This regularization, my lord, the office order,
Yes.
this came into effect after the new pension scheme was brought by the government, my lord. That was way back in the year 2010.
Yes.
My grievance is, my lord, that those persons also who have been regularized after the new pension came into effect, my lord, they were also given the benefit of the old pension scheme.
Anything specific written here?
No, no, my lord. So, my lord, we approached the...
So, where do you find that assertion of yours?
Lordship. No, then after that, my lord, thereafter, we approached this honorable court.
No, you were saying, see, earlier you were saying
Yes, my lord.
that by virtue of this office order,
Lordship.
dated 10/4/2012, so a number of
employees, my lord,
teachers,
my lord,
were regularized.
Lordship.
Services were
regularized.
Were you included in this list?
No, I was not included in this list, my lord.
You are included.
I was not included. But one of my counterparts his name was included in the list, my lord. That is why we approached the court, my lord. And this honorable court was pleased to pass an order, my lord, that would be at Annexure 4, saying that I may be allowed to file a new representation, my lord, before the concerned department.
Eventually, you were also included in the list.
Then later on, by virtue of this order, my lord, then we submitted representation. Then after they considered my representation and they regularized
your services.
My service.
Okay.
In the year 2019.
Oh, that was 2019.
It was in the 2019, my lord. So,
where is that?
That order, my lord. That order would be at Annexure 6, my lord. Page 41.
Annexure 6.
Annexure 6, my lord.
Petitioner regularized.
Regularized, my lord. If I may be allowed to read. On the recommendation of the committee constituted dated 23 September 2019 based on the Honorable High Court of Meghalaya 16/9/2019 in WPC 163 of 2017, the government Meghalaya is pleased to declare Shri Kremen Daka, assistant teacher of the Pending Langsnyang Presbyterian LP School, Mairang, as a government LP school teacher with immediate effect, my lord.
With immediate effect.
Lordship. Thereafter, my lord, initially before this order of regularization, they were maintaining my service book as well, my lord.
Yes.
So they were also maintaining my GPF also at that point of time, but later on they somehow revoked that GPF also, my lord. So being aggrieved, my lord, I'm coming before this honorable court saying that since my date of appointment was way back in the year 1992, I should be allowed to avail the benefit of old pension scheme, my lord. And if lordship can kindly come to the Meghalaya taking over District Council Primary School Act of 1993, my lord.
This
Section 3. Yeah, this is the one, my lord. Yes.
1993, oh yes.
This act came in 1993, but came into force, my lord, in the 2nd June of 1994.
Just a moment.
Lordship. Judgment. Thank you, judgment. Thank you, judgment. Section 3, my lord.
3.
If I may be allowed to read, my lord. On from the appointed day of DCLP school in the autonomous district shall stand taken over by and vest in the state government. On the taking over of the schools under subsection 1 of the liability on account of salary and allowance, including any area thereof, a teacher who immediately before the 20th day of December 1993 is a teacher of such school shall pass on the state government. And gratuity and pensionary benefits of a DCLP school teacher, including any area thereof, for any period commencing from the cut date, shall be borne by the state government. This is very much clear, my lord. And kindly come to subsection 3. The provision of clauses A and B of subsection 2 shall also apply to DCLP school teacher who is deputed or transferred by the state government to serve in a school not being a DCLP. A cut-off date is 1993, my lord.
This will not apply to you.
No, not this one, but subsection 2 will be applied to me.
We're talking about the cut-off date.
Yes, I'm talking about the cut-off date, my lord. Cut-off date is 1993, wherein I'm appointed away 1992, my lord. And similar situated person also, my lord, approached this honorable court, and Justice, thank you also, my lord, has passed judgment. Of course, does not have any bearing, my lord, but I'm just bringing it for the reference, my lord. The relevant portion would be, my lord, that here also it is judgment, my lord. Those persons who are appointed regularized much later, my lord, after coming of that new pension scheme, my lord, they were given the benefit of the old pension scheme, my lord.
And how you say that this case is not relevant to you?
Why is it relevant to me, my lord?
You said it's not relevant to you?
No, it is relevant, my lord. I'm just saying it may not have a bearing because of
Or may not
have bearing, my lord. But I'm just bringing it for the reference of this honorable court, my lord.
If you are citing a principle, if it is there, then it would have relevance, no doubt. What is the para cited?
The para would be 11 and 12, my lord. A conjoint reading of the letter dated 27/8/2007 and order dated 27/5/2000 clearly reflects that the period of ad hoc appointment of the incumbent was to be taken into consideration for the purpose of leave, pay, increment, pension, etc. as per existing provisions. The provision also has been laid down in this district council, taking over district council primary school teachers, my lord. So the appointment of the petitioners or regularization thereof being made under the said precondition. It would only follow that an exception was carved out as far as the petitioners were concerned for the purpose of leave, pay, increment, pension, etc. The guidelines for implementation of the new defined pension scheme, as given in clause 3.1, page 29 of the writ petition, provide as follows. The scheme shall be applicable to all new entrants joining state government service on regular basis, sanctioned vacant posts on or after 1 April 2010. It shall also be applicable to all government employees whose services will be regularized against regular posts on after 1/4/2010 with the benefit of prospective date. The said clause in no uncertain terms has stipulated that the scheme shall also be applicable to all government employees whose service will be regularized against regular posts on or after 1st April 2010 with the benefit of prospective date. In normal circumstances, the scheme would have applied to the petitioners, but however, in view of the condition as noted earlier, which is special and specific in nature of the service condition of the petitioner, the same will be therefore entitled them to be excluded from the implementation of the new defined pension scheme 2009 as far as they are concerned, my lord. Because in the ad hoc rules also, my lord, the pension also has to be calculated from the date of their initial appointment, my lord. Similarly, in this act, my lord, it has been laid down in section 3, my lord, that if you have been appointed prior to 1993, then you'll be getting the benefit of the old pension scheme. That is my case. Since I fall under the purview, my appointment falls under 1992, my lord. No matter I was regularized in the year 2019, but since the section clearly reflects, my lord, that if my appointment is prior to 1993, then I will be given the benefit of the old pension scheme, my lord.
Yes.
In my respectful submission, my lord, the petitioner is mistaken. My lord, in the earlier round of litigation, my lord, in fact, we had filed a very detailed affidavit, my lord. Now, the school in which the petitioner was appointed, my lord, it was not under the district council, administration of the district council. My lord, we had in the earlier round of litigation, my lord, if my lord requires, we call for those records, my lord. We have given the list of the schools which fall under the district
don't have
council.
it with you.
My lord, currently I don't have it, my lord. But we had given a very detailed list of schools, my lord, which fell under the district council and which was taken over. And the petitioner school is not one of them.
Okay.
And my lord will kindly see the nature of appointment. The appointment service book is maintained, yes. But appointment is made by whom? Appointment is made by the managing committee. I will take my lord to the service book of the petitioner itself, my lord. My lord,
It is
page
by the
24
Deputy Inspector of Schools, my lord.
Yes, he is the approving authority. My lord will kindly see. Page 24. If I take my lord to page 24.
But Mr. Charji,
Yes, my lord.
if you see that the records of the the other case is relevant, then it has to be here.
My lord, because we had filed a very detailed affidavit giving the list. Otherwise, what I can do, my lord, I can request them to again give me that list. If I'm able to, my lord, get that, then we do not need to call the old record. Otherwise, my lord, this honorable can call for the old
Not
record.
necessarily. This court would not want to call for records which matter which have been disposed. But if that is within your
Yes.
possession, then you.
I'll have to request them, my lord. Because that time when the schools were taken over, we had given a very detailed, thick list, my lord. So the petitioner school was nowhere there.
Can you do it tomorrow?
Tomorrow will be difficult, my lord. For that, I'll take some time then, because it's a pretty old matter, my lord. If 2 weeks time is granted, then I'll be able to. I hope I'll be able to, my lord.
Mr. Movement is not in that case.
No, earlier on some other, my lord, council
Somebody was
there.
appearing, my lord.
It was Mr. Suna, my lord, SM Suna.
Then you can do one thing. If you get it in your possession,
My lord.
then give an advance copy to it.
Lordship.
Yes. And there are also similar cases, 3 cases were there, my lord. Harun Roy Manar is one of them, and another 2. Now I don't know what my friend is relying on today. That also, my lord, this honorable court has not granted the prayer, my lord. I'll bring those on the next.
See, there's why. See, if those are authorities you want to rely on, you can do it.
My lord, most importantly, if you are expecting a relief, my lord, then you have to fall within that category, my lord. If you are not falling within that category, you cannot.
Because you have to fall under the purview of this act.
Yes, exactly, my lord.
So you cannot claim relief.
Lord, that is, I understand, my lord. But I'm saying that I fall under that purview, my lord. That is why I'm.
No, this same
Now you will
issues.
say otherwise.
Lordship.
Same
That is what, my
issues
lord.
were raised in the.
So let them produce the documents, my lord.
So you give an advance copy. How long?
Lord, I'll pay for 2 weeks, my lord, at least.
Or the argument of Mr. A.G. Mohan, letter counsel for the petitioner. Stop. In his reply, Mr. K.P. Bhattacharya, letter G, has submitted that there are some relevant papers which are necessary to be produced for this court, but could not be done so today, which would support the case of the respondent. And as such, it is prayed that some more time will be allowed for such documents or papers to be produced. On pre-made, same is allowed. This is matter of 2 weeks.
My lord.
We should give an advance copy to Mr. Mohan.
My lord, It can come after the vacations, my lord.
We'll come after vacation.
My lord.
This is a matter of the vacation.
I'll oblige, my lord. Oblige.
Item number 11.
May it please your Lordship.
Yes.
Lordship, there are two writ petitions, my lord. One is Priyanchi and the other one is, my lord, Silka. Now, your Lordship has seen on the earlier round, my lord, on previous date of hearing, your Lordship has seen the facts in Priyanchi, my lord, and facts in Silka are also somewhat similar, my lord. Let me begin with Priyanchi, my lord, because at least because there are so many overlapping facts, my lord. Kindly see the writ petition first, my lord. What is the writ petition which has been filed by the petitioner here? What is the prayer in this? My lord, synopsis, your lordship may see.
Just a moment.
Yes, I'm sorry, my lord.
So you are referring to
writ petition number 279, my lord.
Yes.
That is item 11.
Yes,
and item 12 also, both are for almost similar relief, my lord.
Yes, let's go first with this 279.
Yes, lordship. Kindly see the synopsis.
Yes.
The petitioner begs to state. Lordship got it?
Yes,
Synopsis.
yes,
Petitioner begs to supply of consider for supply of 3,248.5715 quintal of cattle feed, 1,428.5717 quintal of pork feed, and 1,428 quintal of poultry feed for 35 at the rate of 35 kg to affected animals as per norms and approved rate of expenditure for supply. Your Lordship may kindly mark as per norm and approved rate of expenditure, because the petitioner's contention is that it is as per norm and state contention is that it is not as per norm.
Yes.
Now, your Lordship, kindly see the next date.
Yes.
Affected accordingly, while later dated 8 December 2014 and 21st January 2015, respondent district animal husbandry officer North Garo Hills directed petitioner to supply the above requirement of cattle feed, and petitioner successfully completed, my lord. So your lordship may kindly mark these two dates, 8th December 2014 and 21st January 2015.
Yes.
These are the dates which will be relevant with the and your lordship may mark one more, may kindly note one more date, that is 14 September 2014, where on the date on which flash flood has taken place in North Garo Hills.
Where do you find that 14 September? It's not here.
That assertion is there in the writ petition, my lord. I will just your lordship kindly note 8 December 2021 January, and I will show that part also in the writ petition. It is mentioned, my lord. Now, lordship will kindly see the second page of synopsis. That is almost period of 7 years. Second line, my lord.
Yes, yes.
Failed to relieve the bill of 2 crore rupees. So, the admitted case of petitioner is that the petitioner is approaching this honorable court after 7 years, my lord. That is the admission of the petitioner in the writ petition, my lord. That is one admission, my lord. And now, your lordship will see the writ petitions, where the assertions are there.
Yes.
Your lordship, rather than I taking your lordship to the writ petition, I will first show the prayer itself, where the prayer is at page 10.
Yes.
And prayer in 10 is that that inordinate delay on the part of the state respondent to release the bill of the petitioner as unconstitutional, illegal, and further please to release the bill of the petitioner within a period of 3 months. So, what is being prayed, page 10, my lord,
Yes.
of the writ petition, and what is being, in my humble submission, is being prayed from your lordship is direction to state to perform the contract, a specific performance of the contract, my lord, that there is a order, that order has not been complied, and therefore the payment has to be made, my lord. That is what the prayer of the writ petition is, my lord.
Yes.
Kindly, the foundation of the writ petition is based on a minutes of meeting, my lord, which is at page 14, minutes of the meeting at page 14.
Yes.
This is the proceeding of the meeting held on, my lord, annexed by petitioner is on 5th December 2014, page 14, your lordship got
Yes,
it?
yes.
By
Yes,
additional deputy commissioner, so and so, my lord. Now, in connection with slightly not legible, but fine.
with the approved rate of transportation.
Yes, approval rate of the cost and for supply of feed in North Garo Hill district, my lord. Present, my lord.
Yes.
Meeting was chaired by so and so, my lord. All members are present. Meeting and discussion, he gave the brief outline highlighting the objective and purpose of calling the meeting, my lord. Meeting decided first to constitute the committee in connection with the approved rate for supply of feed on urgent and emergency need for the supply of animal and poultry feed due to recent flash flood on 22nd September 2014, my lord. So I'm sorry, I put the date I gave your lordship was 22nd September 2014 is the date on which flash flood has taken place, my lord.
Yes.
The committee.
Yes.
The committee of the meeting discussed above the approved rate of the transportation cost and supply of feed for animals and poultry feed in North Garo Hill district, my lord. After threadbare discussion, committee of the meeting approved the rate at the rate of 35 rupees, my lord, per kg transportation supply of animal and poultry feed for affected North Garo Hills. People in North Garo Hills, they approved. Now the meeting approved, my lord, 3 number of suppliers for cattle and poultry feed for livestock medicine. Lastly, the meeting. So meeting also approved 3 suppliers, my lord. No tender, no short tender, no notice, nothing. So this is the meeting. Now based on that, my lord, on page 15, your lordship will see the date of the meeting is of 5th December. Based on that same day.
Yes.
Now, supply of feed for affected and flash flood occurred on 22nd September. Subject your lordship has seen.
Yes.
Sir, in view of the urgent need for supply of animal and poultry feed, the following supplier may be considered for supply of feed as per norms and approved rate of expenditure for supply of so and so. The copy of your letter, my lord, now dated to the undersigned may kindly be seen enclosed with the approved rate of so and so. Now, your lordship will kindly notice the date of the letter of the petitioner is of 24th November 2014. The meeting has taken place on 5th, my lord. Meeting did not go for any tender, etc., my lord. Norms are to be satisfied, my lord. Norms are required to be satisfied in government tender or government contract, even on emergency basis, my lord. Public money, when public money is involved, the officers and everybody is required to follow the norm. We cannot spend money without following the norms. But be as it may, my lord, on the case of the petitioner before your lordship is that on 22nd September 2014, a flash flood has taken place in North Garo Hills. Pursuant to flash flood, a meeting was held on 5th December by additional deputy commissioner, the revenue. He decided to enlist 3 farms for supply of cattle feed, my lord. The animal husbandry officer, my lord, on same day writes to the petitioner that you have already given a letter prior to the meeting on 24th 11 and the rate is approved, my lord. That is how the facts are placed before your lordship. Now kindly see annexure 6, page annexure 3, my lord.
Yes.
Now annexure 3 is a letter, my lord, purported letter by district animal husbandry officer, my lord. He says,
yes,
that I am requested you to kindly supply the following quantities of cattle feed and pig feed to different dispensaries.
Yes.
Different and aid center for distribution as per list enclosed and submit for bill for necessary action. Now, cattle feed, my lord, of 8th December, my lord, for flash flood which has taken place on 22nd December is placed, my lord.
22nd
Because
September
your
or
lordship
December?
will notice 22nd September 2014 is the flash flood, my lord. 5th December is the minutes of the meeting. 8th December, your lordship may kindly the order placed on the petitioner by purported order by petitioner to supply not less than 3,428 quintal of cattle feed and pig feed, and that rate will be 35. This is the 8th December, my lord, almost 2.5 months after 2.5 months from the flash flood. Flood, my lord, flash flood will not be there in December. Flash flood, but be as it may, these are all disputed facts, my lord. Kindly see what happens next, my lord, at page 17 as placed by the petitioner before your lordship.
Yes.
After 2.5 months, and then another order, my lord, after 3 months, my lord.
Yes.
Page 17, my lord. Again, one more order is placed by. These orders are all above 50 lakh rupees, my lord. Your lordship is aware that in all these matters there should have been some tender. There should have been some procedure, my lord. But be as it may, the case is based on these facts, my lord. So I have to place these facts. Page 17, my lord. Kindly see page 17. I am requested you to kindly supply the following quantities of poultry feed to different dispensaries and aid center for disputes as per list enclosed. Again, 1,420 quintal of poultry feed, my lord. And previous page, your lordship has seen that cattle feed, pig feed, and it was added poultry feed, my lord. After 3 months, for poultry, they wanted to supply how much, my lord? 1,428 quintal. I don't know this poultry feed will be good enough for how many. Now, my lord, then the next document relied upon by the petitioner before your lordship is the utilization certificate.
Yes.
Has been and your lordship will see everything is utilized. I don't know, date is not there. I don't know when was this date. Petitioner should have got the date also, as he has got the orders, my lord. Petitioner should have got the date of the utilization certificate also.
Yes.
But there is no date is mentioned, my lord, and your lordship will kindly mark this received in good condition and has been fully utilized for distribution to the families affected by flash flood which occurred. So what is being said here, my lord, that it is being distributed to the families affected by flash flood. Your lordship would recall that the issue was whether did you set up the cattle camps, which is one of the requirement for to supply the cattle feed, my lord.
Yes.
The answer which came, my lord, is that there is no camps, my lord, which your lordship will see page another document filed by petitioner at page 19 of the petition, my lord. This is the letter. Now, my lord, Cattle feed was supplied in 2015, my lord. As per the petitioner. According to the petitioner, cattle feed and everything was flash flood on 22nd September, meeting on 5th December. The orders in this 8th December and January, and cattle feed was supplied and utilization certificate has been obtained showing that, my lord. That utilization certificate, my lord, was placed, then it was the bills, my lord. The issue was whether these have been supplied to cattle camps or not, my lord. Now, when it was shown that it was not supplied to, your lordship will see page 19 of the writ petition.
Yes.
Because the issue arose, my lord, that there was no cattle camp. Because requirement of law is cattle camp, my lord.
Yes.
And there was no cattle camp, my lord, and there was nothing of that sort, my lord. So I have shown, my lord, the documents, after documents where there is no supply, and this is the last representation is at page 24, my lord. 24,
No,
because
what does Annexure 6 says?
Annexure 6 says that Annexure 6 is document where my lord is that with I'll read out that Annexure, my lord. Annexure 6 says that with reference to the letter on the subject title, I am forward of herewith a copy of letter under a reference received by District Animal Husbandry Officer in connection with the resubmission of bill supply of livestock for families affected by flash flood on so and so on 22nd September. District Animal Husbandry has resubmitted the bill, challan and relief camps set up during the flash flood on now. Because the objection lordship would recall, objection was that there was your bills cannot be accepted. It is rejected.
Yes.
Because there was no camp. And your lordship has seen utilization certificate. It was supplied to the families, my lord.
Yes.
And the region and the argument which was given that because flash flood was not possible to be formed, and therefore, camps were not required, was not possible. Therefore, the camps have not been set up. That was the argument which was given, my lord. When all these issues came, my lord, kindly now in the light of this, your lordship will see ultimately it has been rejected. Way back in 2016, kindly see the chronology of the events, my lord. 22nd September, order is passed. 5th December, purported meeting of the ADC, Additional Deputy Commissioner, Revenue. 8th December, order in bulk. Utilization certificate, no date is given. The flash flood has after 2.5 months. First order is placed after 2.5 months. And second order is placed for poultry feed after 3 months, my lord. Now, your lordship, in this light, kindly see my counter affidavit where I have placed the relevant documents, my lord. I will not take your lordship to the pleading. I will because that document itself is now first document which I am placing before you, my lord, is page 22 of the counter filed by respondent number 5, my lord.
This one.
Counter filed by respondent number 5, my lord.
Just one. Page 22.
Page your lordship will find at page 22, R1.
R1. Yes.
And the heading of the or title of this page is, my lord, revised list of items and norms of assistance from State Disaster Response Fund and National Disaster Response Fund, my lord. Now, period from 2010 to 15, MHA letter dated 16 January 2022, modified by letter dated so and so. So these norms are set by Ministry of Home Affairs, my lord, in respect of disaster and assistance during the disaster, my lord. Your lordship will straight away come to page 24. At page 24 of these norms.
Yes.
And your lordship will find at page 24, heading 6, serials, the
serial number 6.
Item 6, my lord.
Okay.
At page 24. The page 24, animal husbandry, assistance to small and marginal farmers. The title of the serial number 6 is assistance to small. Small Roman 1 is replacement of milk animals, draught animals, and animals used for haulage. And then your lordship will see the on next page.
Yes.
At page 25, small Roman 2, which I am placing before your lordship's kind consideration, is provision of fodder. Your lordship, small Roman 2, left column is provision of fodder, feed concentrate, including water supply and medicine in cattle camps. Your lordship may mark it is in cattle camps.
Cattle camps.
Where
yes.
this provision has to be cattle camps. This is the norm which has to be followed. Now, the requirement is large animal 50 rupees per day. So in cattle camp, my lord, the cattle feed of 50 rupees per day will be given to the farmer. Cattle feed equivalent to. Then your lordship will see a small animal 25 rupees per day. This is the compensation which can be given under the state disaster norms set or disaster fund norms set constituted by. Now your lordship may mark period for providing relief will be as per assessment of state executive committee. So this assessment has to be carried out by a state executive committee, my lord. And the central team, in case of NDRF, the default period of assistance will be 30 days. So maximum period for which the assistance can be given, my lord, is 30 days, my lord.
Yes.
Lordship has taken note that 22nd September 2014 is the date on flash flood has taken place. Under the norms, my lord, norm says that it is the 30 days, which is extendable, my lord. Next line, if your lordship will see, which is extendable to 60 days.
60 and 90 days.
Which may be extended to in the first instance, and in case of severe drought, my lord. So maximum 60 days. It's not a case of drought, my lord, flash flood. Based on now, the criteria is based on the assessment of need by SEC and recommendation of the central team in case of consistent with the estimate of cattle as per livestock census and subject to certificate by as per livestock census, my lord. It's not that animal husbandry officer decides I will place 1,000 quintal of the cattle feed and then state will become bound to pay. Suppose, my lord, if the case is a state animal husbandry officer places the order of 10,000 quintal. Now whether it is supplied by and it is against the rules, against the norms, whether state is bound to honor the order placed by animal husbandry officer on the private party. State, your lordship, is aware that a state is governed by set of rules, norms. It is not the decision of the individual officer, contrary to norms, which will bind the government. Government will be bound if the officer is acting as per norms. That is my.
So, Mr. Kumar, just for your academic
purposes.
Yes, yes, sir.
How much was the order placed for?
If your lordship will see
Just again, let us go again back to the petition.
Yes, orders, if your lordship will see at page, order I have before your lordship, order is placed on 8th December of cattle feed is 3,000.
Just one.
Page your lordship will find at 16, 8 December.
Yes, cattle feed is
3,428.5715
quintals.
Quintal. And pig feed is
no. Just let's go for cattle feed.
Yes,
how do you convert that
into 50 rupees?
Into
Milord.
50 rupees. See how many cattle or how many cows will there
No
be?
data. There is no data, Milord.
No, you can
There is no
calculate.
material.
You can come to a rough calculation from here only.
Because if I 3,428 into 35 rupees, it is the 35 rupees per quintal, Milord.
Yes, so please do that and see.
So if I calculate
Do
roughly,
your
Milord,
calculation and see.
It will be around 1.2 crore rupees.
No, okay, 1.2 crore.
Yes, Milord.
And
because 35 has to be multiplied by, my friend can assist me.
Okay,
35 has to be multiplied by.
Okay, so you divide that by 50.
Yes, Milord. Because no, Milord, what has happened that these poultry feed or cattle feed or pig feed have been ordered at the rate of 35.
Yes, so you see.
So and total amount which is being, if I add all amount which is being claimed is 2 crore.
No, just for cattle feed.
Just for cattle.
Can somebody help me? I got calculator.
28.5.
Then calculator.
I put it in 30.
I would like to get a rough estimate of how many cattle were there for that particular period or for that particular day.
And for your lordship is absolutely right. Your lordship, this is the basic requirement which your lordship is asking me, that you please indicate for how many cattle.
There's no census as such.
And there is no census, no data, no material. And the officer is placing order after order. Your lordship has seen this 3,000. Your lordship kindly take the second writ petition for cattle feed only, for same period only. Silka Disira, that Sirin Disira item.
Is there any?
There is the order. In this also cattle feed order is there. In the other also the cattle feed order is there.
That is a different subject matter. Only
no, your lordship, the subject matter is in both the writ petition is same.
No, that is true. That's what I mean to say is just to get a rough idea of this amount.
How many cattle
it will cater to how many cattle, how many cows.
Yes, your lordship. Yes, your lordship. Cows.
And this covers a period of how many days or how many months?
There is nothing is mentioned. Flash flood, your lordship, is 22nd September 2014.
So flash
floods. That's why I said
flash floods only one. It happened on one day.
One day.
Then the aftermath of it would be, it might
30
range,
days, 60 days.
It might range from 1 to 60 days.
Yes.
So September, October, November.
And orders are being placed when, Milord?
December.
8 December.
Anyway.
8 December means 8 December and order is being placed, Milord. 8 December, Milord. And order will be, and it will take time to get it from Guwahati. Cattle feed is not available in North Garo Hills, Milord. They will get it from some order. Some from somewhere. All what I was trying to broadly indicate to your lordship is that these are disputed question of fact, Milord.
Yes, of course they are. Just I have the calculator with me,
Oh, sorry, my lord.
323428, let's put it that way,
And then,
into 35.
yes, Lord.
That makes it 119980. This is the amount. Divided by 50, because 50, so that will come to 23,996. 23,000.
Yes, my lord.
23,996 number of
Cattle.
cattle.
And your lordship, one more humble request, your lordship. In the other writ petition, my lord, is the cattle feed is 6,000 quintal.
6,000?
For same 6,000 quintal.
6,000 quintal.
Here, 1,000, same 3,000 to 3,428 is here, and the other writ petition is the 6,000. The item
Yes, yes.
is 6,000. So it will I multiply, more than 60,000 cattle will be there, my lord. Now, merely on the basis of, my lord, utilization certificate, everything, my lord.
Yes, please
Can I
continue.
give this money, public money, my lord? Because, and why, if your lordship will see, kindly see the counter, page 22, where I was placing the material, my lord.
Yes.
24 is the scheme, my lord. And there are certain preconditions which are set, my lord.
Yes.
First precondition, if your lordship will see, a cattle camp. It has to be cattle camp. First precondition at page 25, my lord, small Roman 2 of 6, my lord. So first precondition is cattle camp. You have to have cattle camp, then only you can. Second is that it has to be approved by state executive committee. Requirement is state executive committee.
Yes.
In second column, my lord. There is no approval by state executive committee. They do not show anything of state executive committee.
Yes.
Then third is the default period is 30 days.
Yes.
Extendable up to 60 days.
Approved, just a moment. Earlier you saying it has to be approved by state?
Executive committee, if your lordship will see, period for providing relief will be as per assessment of a state executive committee.
Oh, yes.
And central team in case of NDRF. So NDRF is not there, so a state executive committee will come along.
Yes. Period
Then
covered.
second, there is no recommendation, there is no assessment by state executive committee. Third is the default period for assistance will be 30 days. So the default is 30 days, my lord. Fourth is, my lord,
yes,
the based on assessment of need by state executive committee and recommendation consistent with the estimate of cattle as per livestock census. So it has to be consistent. Even if there is a recommendation assessment, it has to be consistent with the livestock census.
Yes.
And subject to the requirement. So requirement also include that, look, we in the camp, the officer will say, when we are governed by rule of law and procedure, officer will say that we have set up 30 camps. In 30 camps, 30,000 animals are there. For this, we require at least this much, and therefore the order is being placed. Your lordship has seen minutes of the meeting. There is nothing, only 3 forms have been approved. How much is the requirement? Nothing. Then your lordship has seen the order, simply I place this order. So therefore my humble submission for your lordship's kind consideration is one, whether based on these 2 letters, order by the animal husbandry officer, meeting of the ADC, additional deputy commissioner revenue, and without following any process, state has erred in not accepting the demand of payment. Your Lordship is broadly considering in the writ jurisdiction the scope of, because the state is saying that norms have not been followed, process has not been followed. This is a disputed question of fact, and there has been inordinate delay, my lord. Because if my friend has, my lord, as on today, if your lordship feels that no, money has to be paid, the supplies have been made, which I don't see anything here. But even assuming, for the sake of argument, my lord, if your lordship comes to the conclusion that no, poultry feed has been supplied, cattle feed has been supplied, and you have availed those, and you are bound to pay. If I take, though there is nothing in this, still, your lordship, I do not know, because as on today, is it possible for me as a state to verify and check whether cattle feed, because you will be supplying, the contractor will be buying the cattle feed from some shops. There will be GST, sale tax invoices, so that if I have to conduct the inquiry as on today, and the officers may have retired in the meantime also by giving those utilization certificate. So delay and latches is also important factor, my lord, because the petitioner is aware, my lord, because if petitioner is aware that petitioner has the genuine claim, he would have filed a suit immediately, my lord, within 3 years, because the rejection is applied in 2000, as per him, order is placed on 8 December 2014. January it was supplied. The petitioner, if I take it to be correct, petitioner must have supplied within 15 days, 10 days. I don't know how many trucks are required for supplying about 9,000 quintal for cattle feed only, and distributing it to the various farms, below. Now, your lordship, kindly, I have shown the norms, because petitioner claim is that I have supplied the material as per norms. They have not, definitely not. Norms have been casualty in the entire process, my lord. Now, your lordship will see the next annexure of mine at page 27, R2.
Yes.
Now, this is the letter of 16th October 2015.
Yes.
This now, the same animal husbandry officer, my lord, who placed the order.
Yes.
He says, subject now, setting up the relief camp for livestock during flash flood, which occurred on 21st and 22nd, 2 days, my lord, sorry, I was 21st and 22nd September 2014. Now, letter is written on 8th October 2015. That letter is not placed here, but doesn't matter, my lord. With reference to the subject cited above, I have to honor to inform you that relief camp for flood affected livestock could not be set up during the flood, due to shortage of manpower. Moreover, the affected villagers were reluctant to bring their livestock and poultry to the relief camps due to fear of misidentification and misplacement, because poultry can get mixed up, my lord. Most of the affected villages are interior areas, and the roads and bridges connecting to their villages have been washed away during flood, making it all the more difficult to bring their livestock and poultry to the camps. So the relief camps meant for them are left unused, and feed for livestock and poultry were distributed through village Ganburas, Nokmas, Sardars, and Village Employment Council members for proper distribution in respective village and areas. So then when the question was raised, my lord, that did you supply the cattle feed, whether the cattle feed was supplied to relief camps, because norms require you have to supply the cattle feed or give 50 rupees per cattle, your lordship has seen. Then the answer came that it was not possible. The villagers were in interior, and it was distributed to the local sardars, Ganburas, etc. Now, when the rejection letter came, my lord, on next page, by saying that it cannot be sanctioned, my lord, that letter is at page 28. Next page, my lord, of my counter.
Yes.
And the counter affidavit, my lord, in the page 28 of my counter affidavit, that letter is very clear. I am directed to refer to the letters cited above. All those 20th October, all those letters are there, and to say that, my lord, kindly mark this. Item 6, small Roman 2 of State Disaster Response Fund. Norms states that provision of fodder, feed, concentrate, including water supply and medicine in cattle camps. I have placed, my lord, norms in item 6, small 2 of State Disaster Fund, my lord. Since feed were supplied outside the cattle camps, the proposal of sanction of fund of SDRF for payment of bill is not eligible under the items and norms for State Disaster Response Fund, my lord. In view of the above, bills and our connected papers are written here. Your Lordship have seen norms require assessment by State Executive Committee. Default period is 30 days, my lord. Then consistent with the livestock census. These are the, so both on the count, both counts, my lord, that norms are not, both counts that cattle camps are not set up. Secondly, norms have also not been met, my lord. Your Lordship will see that norms once again at page 25. Norms are very clear, my lord. Your Lordship has calculated also.
We have gone
so
that,
therefore, I need not. Now, what happened, my lord, when it was clear and clear as possible, my lord, now they give a spin to the whole story, my lord. And spin is, your Lordship will see, Mr. Sangma, the animal husbandry officer, now he says at page 29.
Yes.
29. Now he submits the after, my lord, 2016, in after 2 years now, in 20, then when rejection is passed, my lord, on 3rd February 2016.
Yes.
The petitioner sleeps over his right. Petitioner is not now concerned, bothered. Now he is thinking how to overcome the challenges, my lord. And now attempt has been made to overcome the challenge at page 29. Referring to the above letter, I am the honor to state that in bill submitted earlier, there were miscalculation. Amount of bill, quantity of feed distributed has been duly corrected. Local ID also include so and so. Now corrected challenge, etc. Kindly see page 30, my lord. Most important page which I am placing relied. Page 30, next page.
Yes.
Now, what is being now? This is a new. This page, this letter of 2016. Earlier, your Lordship has seen, because this has to be seen in the context of 3rd February 2016 letter, and this is a letter of 19th April 2016. 3rd February 2016 letter at page, your Lordship has taken note, is of page 28. At page 30, my lord, 20, this where the rejection is passed because norms are not met, cattle camps have not been set up. This is at page 28. At page 30, your Lordship will see, in reference to the letter cited above, I have the honor to inform, page 30 is the, the same letters, my lord, page 30, along with the list of relief camps set up during flash flood, and that part of 20, the earlier clarification regarding setting of relief camp was a mistake and it is highly regretted. So now, attempt has been made by the officer and in collusion with the petitioner. I have no hesitation in saying that at page 28, very witty reasons have been given that there will be misidentification. Your Lordship, kindly see.
Yes, that I recall.
Yes, page 27, where the reasons have been given
why
for
the camp has not been set up.
Set up. And now one line reply is being given because when the rejection came, my lord, rejection came at page 28 on 3rd February 2016. Then in order to overcome the rejection, what is the line Present clarification regarding setting of the relief camp was a mistake and it is highly regretted. So misidentification of the animals disappeared. The bridges and roads have been washed away, disappeared. The reluctance on the part of the villagers to bring the cattle to the camps disappeared. And one line is regretted. In my understanding, according to me, Milord, why they are trying to do is when state said in clear terms in February 2016, at page on 3rd February 2016, that your proposal and your claim is not consistent with the SDRF norm or the norms 6.2, which says that these are the requirements. So they try to meet one of the requirement. One of the requirement is that cattle has to be in cattle camps. Then only, as per norms, you are entitled to ₹50 per day. So this was the spin to the whole story. And I have no hesitation. There is some collusion, but your lordship ultimately. Lordship has to see the larger picture, and as a lawyer of the state, I have to see the larger picture, my lord. That whether I should agree to give this kind of money to the supplier who may not have supplied, or if I supplied, he should have come to the court or to the state government within a reasonable period, so the inquiry can be conducted.
Yes.
After 8 or 9 years, my lord, nothing can be done. This is the now your lordship will see the law is on this issue is well settled, my lord. And just see the other writ petition also, so that my factual narration will be complete, my lord, because the other writ petition is also there, my lord. 359, your lordship. 359. Slightly different case, but by and large, nothing much changes in that case also, my lord. 359.
Yes.
Same page 30, my lord. Minutes of the meeting. Of 5th December. This is typed copy, so readable, my lord.
Yes.
And if your lordship will, the lordship has calculated the figure also, my lord. Paragraph 3, my lord.
Yes.
After threadbare discussion, the committee of meeting has approved rate at the rate of 35 per kg for transportation.
Yes.
And supply of feed. Here norm says 50 rupees per day per cattle.
Yes.
So the committee also, and committee is what? Committee is consisting of additional deputy commissioner revenue. It is not state executive committee. There is no assessment, my lord. So this committee itself was not competent. And then on page, my lord, 32, your lordship will see. Page 32.
Yes.
Cattle feed 60,000 quintal and pig feed 2,500 quintal.
Yes. Please continue.
And your lordship kindly see next page, my lord, page 33.
Yes.
Cattle and pig feed to be distributed to different dispensaries and aid center. Now here, my lord.
Yes.
Because this is the subsequent rate, my lord. Then the centers are Rasbulpara, CNRD block, and Kharkuta CNRD block. Now this is the quintal. Here in the same camp, Priyanchi also, my lord, supplied cattle feed, pig feed, and poultry feed. Selka also provided, my lord, without censor. This is the, then your lordship, after cattle feed, pig feed. There is one more order which was placed, my lord, is poultry feed, my lord, on 21st January. Identical orders at page 37. (37) is the type copy, my lord. That is more legible.
Poultry feed.
Poultry feed 10,000 quintal, my lord. And the earlier writ petition, your lordship has seen that poultry feed was of, sorry, my lord, this is so much. It was of 1,428 quintal, and now it is 10,000. 10,000 is the 10,000 quintal, my lord. Now, your lordship, kindly see the claim at page 39. Calculation is there. Thankfully, my friend has calculated.
Yes.
And interestingly, my lord, the orders, the claim is also of 15 December 2014. 15 December, 8th December order is placed, my lord. The lordship has taken note. No, in this case, one more interesting fact is there, my lord. I just noticed. Page 30, your lordship has seen the minutes, and the order is minutes is of 5th December, my lord. Minutes is of the 5th December. And the order in this case is not of 1st December, my lord. Kindly see page 32, before minutes, my lord.
Yes. Page 32.
32, your lordship. This is the order dated 1st December 2014. Forgery is also not properly done.
What is the type copy of this?
If type copy is at page 34.
1st December.
1st December. And minutes of the meeting is, your lordship has seen, 5th December. So before minutes is also there.
Oh.
Everything is done, my lord. Mr. Mandal, Animal Husbandry Hospital, is very generous to the petitioner, my lord.
Order is dated 1st
December. And, my lord, supplies have also been made at page 39 on 15 December.
Yes.
At 15 December, my lord, of 2,97,50,000 rupees. And the next page, my lord, poultry. Poultry has to, my lord, I can't imagine. Poultry.
Yes.
So much. It's like Chara Ghotala in Bihar, my lord. It's page 35, my lord. Poultry feed 10,000 and multiplied by 3,500 per quintal. It comes to 3 crore. I was wrong, my lord. It's 3,500 per quintal. 35.
Yes, 3,500.
3,500. So
because they have agreed at 35 rupees per kg.
Kg. I'm sorry. That's why my figure was wrong. My figure was wrong. So 35 rupees per kg, my lord, to poultry.
Yes.
Poultry, we will get so many poultry. 10,000 poultry is chicken, duck, and how many poultry in 10,000? Your lordship has calculated 10,000. How many poultries can be fed for how many days?
That is not.
It will be sufficient. It will be sufficient for the whole of the Meghalaya, my lord.
Whole of Meghalaya.
10,000, my lord, 10,000 metric ton. Sorry, 10,000 quintal. It's a huge. It's a huge. So, and that is the claim is at page 43, my lord. It's 6 crore 47 lakh 50,000 rupees. And those representations come to your lordship in 21 or thereafter, my lord.
Yes.
So they are there, my lord. So at the end of the day, my lord, what is being prayed in in both the petition is claim A, my lord,
Yes.
that the petitioners have supplied the cattle feed, poultry feed, pig feed as per the order placed by animal husbandry officer, who in turn has placed these orders based on the minutes of the meeting of the additional deputy commissioner revenue. And on that basis, claim is being made by the state against the state. State is disputing number of factors. One, A, that norms have not been followed. Therefore, state is saying since norms have not been followed. B, state is saying that these are disputed question of facts because there is no cattle farm, cattle farm or cattle camp set up by the and the facts are convoluted. When the objection is raised, then they say that no. And third, state is saying before your lordship very humbly that these are also suffered, these claims are also barred by delay in laches, inordinate delay in laches. And lastly, my lord, the fact of the matter is that these are all disputed question of facts, my lord. My lord, I have given a judgment compilation on these issues, my lord. Now kindly see the legal position on these facts, my lord. On last of date of hearing, I have given the judgment compilation, my lord. If your lordship will see the judgment compilation, which is of 189 pages, my lord.
For both cases?
Both cases, my lord, the compilation is the legal position is not different. Facts are also similar, my lord. First, if your lordship kindly see the index itself, my lord, my index of the compilation, my lord.
Yes.
First heading is, my lord, first heading of my judgment compilation is barred by limitation. Second heading is contractual nature, thus no writ, my lord.
Yeah.
So I have divided my legal submission in two parts, my lord.
Yes.
Contractual, and within that disputed question of fact is also there, my lord. Now kindly see the third submission is disputed question of fact, so therefore writ is not maintainable. Your lordship, kindly see the first judgment, paragraph 24 of the first judgment on barred by limitation, my lord. Paragraph 24 at page 29. Legal position in these two paragraphs have been very aptly placed by the Honorable Supreme Court.
Yes. Just a moment.
Paragraph 24 at page 29. Now it is well settled.
Yes.
That power of the High Court to issue an appropriate writ under Article 226 of the Constitution is discretionary, and the High Court in the exercise of its discretion does not ordinarily assist the tardy and the indolent or acquiescent and the lethargic. Is discretionary, and the High Court in the exercise of discretion does not ordinarily assist the tardy and the indolent or acquiescent and the lethargic. If there is inordinate delay on the part of petitioner in filing writ petition, and such delay is not satisfactorily explained, High Court may decline to intervene and grant relief in the exercise of its writ jurisdiction. I pause here for a moment, my lord. I can take your lordship to the entire writ petition. No reason has been given by the petitioner as to why petitioner is approaching this honorable court in 21. One or two representation in here and there will not be explanation below. But the purported or alleged supply of the cattle feed, of the poultry feed, or pig feed have taken place either in December or in January as per the petitioner below of 2015. And no reason is given why after 7 years or 8 years.
Yes.
So there is no whisper, my lord, and representation will not extend the limitation. If there is an inordinate delay on the part of petitioner in filing a petition and such delay is not satisfactorily explained, High Court may decline to intervene and grant relief in exercise of jurisdiction. The evolution of this rule of laches or delay is premised upon number of factors. High Court does not ordinarily permit a belated resort to the extraordinary remedy under the writ jurisdiction because it is likely to cause confusion and public inconvenience and bring in its train new injustices. Right of third party may intervene, and if the writ jurisdiction is exercised on the writ petition filed after unreasonable delay, it may have the effect of inflicting not only hardship and inconvenience but also injustices on third parties. When the writ jurisdiction of the High Court is invoked, unexplained delay coupled with creation of third party right in the meanwhile is an important factor which always weigh with the High Court in deciding whether or not to exercise such jurisdiction. We do not think it is necessary to burden this judgment with reference to various decisions of this court where it has been emphasized time and again that where there is an inordinate and unexplained delay and third party rights are created in the intervening period, High Court would decline to interfere even if the state action complained of is unconstitutional or illegal. We may also mention Ramanna Dayaram Setti versus International Airport Authority of India and other in Ashok Kumar Mishra versus Collector. We may point out in R.D. Setti's case, even though state action was held to be unconstitutional as being violative of Article 14, this court refused to grant relief in the petitioner on the ground that it petition has been filed by petitioner more than 5 months after the acceptance of tender, my lord. So delay is, my lord, one. Then your lordship will see the next judgment, Chennai Metropolitan, which is at page 51. Page 51 of my compilation, my lord.
Yes.
And paragraph 12, which is relevant at page 58, my lord.
Yes.
And paragraph 12 and 16, two paragraphs are also, my lord. Paragraph 12 and 16. 12, my lord, is the question which is posed by the Honorable Supreme Court in this judgment of Chennai Metropolitan, my lord. Last 4 lines of paragraph 12. The question, middle of the paragraph 12, my lord, the question that arises is when the charge of unauthorized absence for long period has been proven, was it justified on the part of High Court to take resort to doctrine of proportionality and direct reinstatement of service? That apart, my lord, one aspect which has not at all been addressed by the High Court is that respondent invoked the extraordinary jurisdiction of the High Court after 4 years, my lord. In that case, it was after 4 years, my lord. Our case, my lord, is more than 6 years, my lord. And the answer to this query, this answer to this issue is paragraph 16 at page 16.
Yes.
Thus, because Lordship will see there are judgments are cited in 13, 14, but I'm straight away conclusion I'm coming 16, Miller. Thus, the doctrine of delay and latches should not be lightly brushed aside. A writ court is required to weigh the explanation offered and the acceptability of the same. Court should bear in mind that in exercising an extraordinary and equitable jurisdiction, as a constitutional court, it has a duty to protect the rights of citizens, but simultaneously it is to keep itself adequate region, keep itself alive to the primary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court should be under the legal obligation to scrutinize whether the list at a belated stage should be entertained or not. it noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be fatal, but in most circumstances, inordinate delay would only invite disaster for the litigant who knocks the door of the court. Delay reflects inactivity, inaction on the part of litigant. A litigant who has forgotten the basic norms, namely procrastination is the greatest thief of time, and second law does not permit one to sleep and rise like phoenix. Delay does bring in hazard and causes injury to the list. So therefore, my lord, delay is a factor which your lordship may consider in the particularly in the facts of the case, my lord. Your lordship has noted flash flood on 22nd September 2014, my lord. Meeting of the on 5th December, order is on 8th January, and January, as per according to petitioner, my lord, everything was completed in January 2015. They in any ordinary prudent businessman, my lord, if he has supplied the material worth 6 crore rupees, my lord, or 2 crore rupees, my lord, he will not wait for 6 years to knock the door of this honorable court. He will not wait for, he will, because 6 crore, my lord, in 2015 or even now is a huge amount, or 2 crore rupees is a huge amount. But your lordship has seen the explanation, etc. Now all documents, everything will vanish, my lord. If inquiry is required to be conducted also today, we will not get anything. And their claim is based on mere ipse dixit. So therefore, in the facts of the case, my lord, if your lordship will see the principle of delay as provided in these two judgments, and last judgment also, my lord, at page 67. Page 67 is the Karnataka Power Corporation judgment, my lord, will apply, squarely apply in my humble submission, my lord. Karnataka, page 67 and
Yes.
page 67-2, my lord, and para 6 at page 70, my lord.
6
at page 70.
Yes.
Delay or laches is one of the factors which is to be borne in mind by the High Court when they exercise their discretionary power under Article 226 of the Constitution. In an appropriate case, High Court may refuse to invoke its extraordinary jurisdiction powers if there is such negligence or omission on the part of applicant to assert his right as taken in conjunction with the lapse of time and other circumstances causes prejudice to the opposite party, even where fundamental right is involved. The matter is still within the discretion of the court as pointed out in Durga Prasad versus Chief Controller of Imports and Exports. Of course, the discretion has to be exercised judicially and reasonably. What was stated in this regard by Sir Burns Peacock in Lindsay Petroleum versus Prosper Armstrong Heard was approved by this court in Moon Mills versus M.R. Meher and Maharashtra SRTC versus Sri Balwant Regular Motor Service. Sir Burns had stated, now the doctrine of laches in courts of equity is not an arbitrary or a technical doctrine where it would be practically unjust to give a remedy either because the party has, by his conduct, done that which might fairly be regarded as equivalent to a waiver of it, or where by his conduct and neglect he has, though perhaps not waiving that remedy, yet put the other party in a situation in which it would not be reasonable to place him if the remedy were afterwards to be asserted in either of these cases. Either of these cases, lapse of time and delay are material. But in every case, if an argument against the relief which otherwise would be just is founded upon mere delay, that delay, of course, not amounting to bar by any statute of limitation, the validity of that defense must be tried upon principles substantially equitable. Two circumstances always important in such cases are length of delay and the nature of acts done during the interval, which might affect either party and cause a balance of justice or injustice in taking one course or the other, so far as it relates to the remedy. These are the golden words, my lord, which are consistently being followed by this honorable court and by honorable Supreme Court. Paragraph 88, my lord. It would be appropriate to note, my lord, so paragraph 8 also, my lord. It would be appropriate to note certain decision of this court in which this aspect has been dealt in relation to Article 32 of the Constitution. It is apparent that what has been stated as regard that article would apply a fortiori to Article 226. It was observed in Ravindranath Bose versus Enough India that no relief can be given to petitioner who, without any reasonable explanation, approaches the court under Article 32 after inordinate delay. It was stated, though Article 32 is a guaranteed right, it does not follow from that this was the intention of constitution maker that this court should disregard all principle and grant relief in petitions filed after inordinate delay. It was stated in the state of MP versus Nandlal Jaiswal that High Court in exercise of discretion does not ordinarily assist the tardy and the indolent or acquiescent and the lethargic.
And that has already been, you have already referred to this case.
Yes, Your Lordship, my Lord. I need not repeat myself, my Lord. Now, second heading is, my Lord, rather the contractual nature, thus no writ, my Lord. And page judgment is at page 73. Radhakrishna Agrawal. And the relevant paragraph, my Lord, is paragraph 17 at page 80.
Just one. Para
17 at page 80.
Yes.
Now, because similar argument will be advanced and has been advanced by my learned friend below, paragraph 17.
Yes.
And that argument is taken note in paragraph. The learned counsel contends that in cases before us, breaches of public duty are involved. They will say that it is a breach of public duty, therefore writ is maintainable. The submission made before us is that whenever a state or agents or officer deal with the citizen, either when making a transaction or after making it acting exercise of powers under the terms of contract between the parties, there is a dealing between state and citizen which involves performance of certain legal and public duty. If we were to accept this very wide proposition, every case of a breach of contract by the state or its agent or its officer would call for interference under Article 226 of the Constitution. We do not consider this to be a sound proposition at all. So in every breach, my lord, writ court, private breach, writ court is, the writ remedy is not available to the citizen, my lord, because there is a distinction between a private contract and a duty performed as a public duty. Lordship is aware of that, and that is what explained in paragraph 18. Yes. Learned counsel for the appellant cited certain authorities in an attempt to support his submission that the state and its officers are clothed with a special constitutional obligation, including those under Article 14, in all the dealings with the public, even where a contract is there to regulate such dealings.
Yes.
And then after citing those in paragraph 18, Miller, in 19, paragraph 19, we do not think that any of these cases could assist the appellants or is at all relevant. None of these cases lay down that when the state or its officer purport to operate within the contractual field, and the only grievance of the citizen could be that of contract between the parties is broken by action complained of, the appropriate remedy is by way of appropriate remedy is by way of a petition under 226 and not under, or there is a formidable array of authorities against any such proposition. That writ is the remedy and suit is not the remedy, my lord. Yes. That the Honorable Supreme Court says there is a formidable array of authority against any such proposition, and these propositions are noted here, my lord, below that. These are the judgments which says that. And paragraph 20, learned Solicitor General appearing for state content, there could be no aspect of Article 14 involved in cases where no comparison in facts and circumstances of the case, my lord. So the principle which emerges, my lord, of these cases, my lord, that when there is a complained by the citizen of breach of contractual duty, my lord, the remedy is the suit, not the writ, my lord. Here, breach as per the, according to the petitioner in the facts of the case is, my lord, breach is that supply order has been placed and the money has not been paid. Supply order has been placed by the officer and against supply, money has not been paid. So there is a breach of the contractual. Contract is the order, the order is contract, acceptance of the order is the contract comes into existence, my lord, offer and acceptance, my lord. And after offer and acceptance, there is a breach and therefore the petitioner is asking for writ, has approached the writ court, that too after 6-7 years. My lord, next judgment on this line is at page 85. Page 85. Page 85 is the next judgment, my lord, of the Honorable Supreme Court in Premji Bhai Parmar, and relevant paragraph is, my lord, at page paragraph 8. Paragraph 8 at page 91.
Yes.
Though we are not inclined to reject the petition on the preliminary objection, as we have heard on merit, it is undeniable that camouflage of Article 14 cannot conceal the real purpose motivating these petitions, namely to get back a part of purchase price of flats paid by petitioners with wide open eye after flats have been securely obtained, and petition to court under 32 is not a proper remedy, nor is this court a proper forum for reopening, concluded in view of the getting back part of purchase price and benefit taken, my lord. So what is being sought here also, my lord, is that they want the alleged supply and alleged money, my lord. The next judgment is, my lord, at page 101, my lord.
Yes.
And paragraph 9 at page 109, my lord.
Yes.
Ordinarily, where a breach of contract is complained of, a party complaining of such breach may sue for a specific performance of contract if contract is capable of being specifically performed, or the party may sue for damages. Such a suit would ordinarily be cognizable by civil court. The High Court, in its extraordinary jurisdiction, would not entertain a petition either for a specific performance of contract or for recovering damages. My lord, what they are asking here, my lord, is damages that they have supplied, and therefore this writ court, prayer your lordship has seen, direct the state to pay the amount. So it is nothing but recovery of damages for the alleged supplies made, my lord. And then your lordship in paragraph 9 has seen that this kind of writ is not maintainable, my lord. Next judgment, my lord, is at 113.
Yes.
And paragraph, my lord, is, I will, there are 3 paragraphs, 55, 59, 69. 55, 59, 69. My lord, I straight away, I will take your lordship to paragraph 69, where conclusion has been recorded by the Honorable Supreme Court. 69 at page 151.
Yes.
The position thus summarized, the conclusion which is there, my lord, of 2015 judgment, this is 2015 judgment. Position thus summarized in the aforesaid principle has to be understood in the context of discussion and that preceded, which we have pointed out above. As per this, no doubt there is no absolute bar to maintainability of writ petition, even in contractual matters, or where there are disputed question of fact, or even a monetary claim is raised. At the same time, discretion lies with the High Court, which under certain circumstances it can refuse to exercise. It also follows that under the following circumstances, normally the court would not exercise this discretion. Court may not examine the issue unless the action has some public law character attached to it. My lord, first requirement is it has to be public law. Normally, your lordship will not do it, public law character. And there is no public law character involved. It is between contractor and the officer, my lord. I will say that. 69.2. Whenever a particular mode of settlement of dispute is provided, contract would refuse to exercise its discretion under 226 and relegate the party to the said mode of settlement, particularly when settlement dispute is to be resorted to means of arbitration. 69.3. If there are very serious disputed question of fact, which are of complex nature, require oral evidence for their determination. As on today, what has been placed before your lordship? The supply order and utilization certificate and the rate, my lord, and multiplied, so that whether it was supplied to whom, how many persons, how many cattle, livestock, census, all these involve disputed question of facts, my lord.
Yes.
And if the direction sought by the petitioner is given, my lord, your lordship will say that, look, you have placed the order, this is the amount. You make the amount with whether the order has been received or not, how much has been given, whether cattle feed has been bought by them or not, what is the proof that they have bought it, by which vehicle they brought it to where, which camp. All these are disputed questions. That is why 69.3 in my humble submission will squarely apply, my lord. Money claim per se, 69, particularly arising out of contractual obligations, are normally not to be entertained except in exceptional circumstances. No exceptional circumstances in my humble submission, my lord, is made out. Further, the legal position which emerges from various judgments of the court, the contract, interstate obligation can be summarized under. So this is the paragraph, my lord, 69, 70, lordship may take note while deciding the matter, my lord. The next judgment is, my lord, at page 154. And the paragraph is 22 at 164, my lord. Paragraph 22 at 164.
Just a moment. Let me just note this down.
Yes.
$164.
Yes, my lord.
Yes.
There is a line of decisions where the contract entered into between the state and the persons aggrieved is non-statutory and purely contractual. The rights are governed by the terms of contract. No writ or order can be issued under 226 of the Constitution so as to compel the authorities to remedy a breach of contract, pure and simple.
See,
And then your lordship,
whatever decision that you have cited, they say one and the same thing only.
Yes, your lordship. Only your lordship may take note of this paragraph in next. I will not take your lordship to the paragraph. In your lordship, those paragraphs are already mentioned in my index. Paragraph, my index paragraph is also there. Judgment is also there. Your lordship may take note of those paragraphs in judgment. And then I will conclude my submission by saying three things, my lord. One, that admittedly, my lord, and I will say according to me, and I will see that the supply order is not in terms of the norms which I have placed before your lordship.
Yes.
My second submission is that the writ raises the disputed question of facts, my lord. My third submission is that it is relating to contractual dispute, my lord. There is no public law remedy involved. And last but not the least, my lord, the writ is also hit by inordinate delay, laches, and acquiescence. My lord. That is all I have to submit. I am highly obliged for presenting.
Lordship, we have another judgment of our own High Court, where whether we have placed on last occasion or not, we have our own judgment that is dated 5/5/2023.
On the issue of disputed question of fact.
Yes, Your Lordship.
Same.
But that one is writ is an order passed in the WPC, and another one is passed in the writ appeal, Your Lordship.
What is the relevant paragraph here?
Relevant para is a very short order. That relevant para is para. First one is 1314, then second one is para 7th.
1314.
One is 1314, one is para 7th. In the writ we have the 1314, then in writ appeal is para 7, Your Lordship. That in WPC is 12, 13 and 14, Your Lordship.
Yes.
And writ appeal is para 7, Your Lordship.
Yes.
My Lord, I'll give a reply. Learned HE has given a marathon submission. I really appreciate the effort, industry on his part in his team. I'll try to concise my reply, Rejoinder, as short as possible.
How long will it take?
My Lord, I'll take 20 minutes, 15 to 20 minutes.
Now we are almost into.
My Lord, 1:10, 1:12 minutes. If we conclude in the second half.
Yes. Consider.
If I appear in the second matter, I had a small prayer, my lord. Since it has come up that whether we have given the supply, which vehicle, which truck, we have got the records of each and every challan, each and every, so to say, a permit or so, which the lordship can only have a look at only one of such. I wanted to bring it by way of affidavit, since they are not placing the record.
My lord, all these are, with respect, my lord, all these are the facts which my friend is disputed. Writ court can't go into the veracity, or I also can't go into the veracity, my lord.
Lordship will see, this is a challan. Yes. The name of the relief camp is mentioned, the name, vehicle number is mentioned, it is countersigned, the quantity is mentioned. So if required, if they are not
See, Mr. Dev, what you are doing is you are reinforcing the fact that there are disputed questions of facts here.
No, I'm not trying. I am categorically saying that each and everything has been done
Exactly.
as per the norms.
Exactly. That is what you assert. On the other hand, the state would say otherwise.
So let them produce the record, my lord. I don't have to.
My Lord, I was contemplating to make prayer.
What my friend is asking that this writ court should permit the parties to lead evidence.
Otherwise, the record is there.
The issue.
I was thinking for calling for record.
Let them produce the record, my lord.
After to call the record, we have to satisfy lordship. Satisfy lordship. And it is a
I am raising the legal maintainability, my lord, and my friends are not having answer. Therefore, they are trying to take your lordship to the issue where this.
I have an answer. Now,
Mr. Kumar, your
I'm sorry. I'm sorry.
Your argument and contentions are duly noted.
Yes.
And will be dealt with accordingly. But,
yes.
But on the other hand, if the court is to come to a...
I can't come in the way, my lord.
If the court is to come to a just conclusion, this court, I mean, it is well settled.
That too, I am completely in your lordship's
It is
hand,
well,
so far as records are
well
concerned.
settled that the court, High Court cannot go into disputed areas of facts.
Yes, lordship. That too, that is the principle which is applicable.
But there are
which is applicable. You know?
But there are also gallows of judgment which says that the court can examine facts.
Yes. Yes. Court, your lordship, is so
as
far
you
as my
rightly-
submission.
as you have rightly-
If I add my rider, my lord, if I add rider
as
to
you
what I
rightly
say,
pointed out,
lordships.
as you rightly pointed
Yes.
out, Article 226 verges on the issue of discretionary power. So, question
Remedy.
of discretion is there, whether the court will do it or
Discretion
not.
is Yes, your lordship, and those discretions have been laid
With
down
due
by your
respect,
lordship
with
that
due
your
respect,
lordship will
the
follow
prayer
the
of my
discretion
friend
in this
Mr.
manner,
Dev
in this way.
would be
In this
relevant
manner
when
and
the
this
lordship
way, my lord.
examine the matter
When-
in their entirety.
Mr. Mr. Dev, see, the point is you may give all the details, all the facts relevant, but the main areas which have been covered by the learned AG have not been answered.
Right. Therefore, it is our
Have not
duty to
been
answer.
answered.
Right.
And this court is of the mind.
Right. In fact,
the only thing is that the money has not been disbursed to you.
Right.
Otherwise, this court is of the mind to hand this matter over to
Right.
CBI.
Right. Discretion
things
is
happen.
discretion is solely in your lordship's hand. And in fact, the prayer made by my friend to bring further evidence, further records, is not appropriate. My suggestion is, lordship may examine, and it is a fit case for calling for records. Everything is mentioned in the record. Now, the contentious issue raised by learned AG, it is our duty to reply it.
That is on facts.
It is a duty.
The legal aspect has to be considered.
Right. We have
Issue
to-
of delay.
Exactly. Therefore, let me start from answering to the question of delay.
If you are insisting that the records is to be produced, then we'll have to call for the records.
Right. It is very
You can
vital.
answer.
Because state cannot just simply file a affidavit and say there is a mountain of disputes. And that the case doesn't necessarily become a disputed facts. The law is very clear. The assertion of the government should be based on the records. And what is the dispute? The dispute is what? The game. Government sanctioning authority is disputing there is no game. And the authorities say that, oh, there was a miscommunication, there was a game. So I will definitely satisfy my lord.
Even the norms have not been complied with, Mr.
Therefore, I will come, my lord. Definitely. Therefore, I will satisfy my lord. Therefore, I'll try to concise my rejoinder.
And without the if the records will show that there was a head count and the details are there, then
Why not? Therefore, it is our duty, since we invoke the rich jurisdiction of this honorable court, it's our duty to pursue, my lord. Otherwise, we can't afford to come and waste the time of this honorable court. We have a grievance. Therefore, it is our duty to show, my lord. So I'll try to concise my reply. And I'm very hopeful that our reply would convince the lordship to take appropriate decision.
if this court, anyway, that will look.
Right.
But if this court finds that you have no case,
yes,
then exemplary course will be imposed on you.
My lord, we will satisfy. Exactly. We will satisfy. But, my lord, therefore, number one, the delay in ledges. Learned AG has stated asserted for delay in ledges. In fact, he was supposed to argue before I opened the merits of the case. If I am unable to sail through, I'm not entitled to go into the merits of the case also.
Exactly.
But I have touched the merits of the case, and so also he has touched. Now he says that
then we'll do one thing. How soon can you produce the records, Mr.
Let him produce.
Lordship, because I feel that records are whatever records we have, my lord. Those records are. I will place it. My friend will place it because those records are probably with Revenue and Disaster Department, because they have what has happened, my lord, that the minutes of the meetings will be there. Those papers which my friend has produced, my lord. In petition, they have produced the order. I have produced the letter, my lord. The facts are not in dispute to the extent, my lord, that there is no cattle camp. I said no cattle camp. They said no, we have. It is regretted by my animal husbandry officer. Said it is regretted. We have set up the cattle camp. Your lordship has observed rightly that cattle camp requires that livestock census data. All these things should be there in record. I'll place that record. Your lordship will see there is no such record. I have also seen. I'll place it because Your Lordship may have it any
the only
by
thing,
hopefully by tomorrow,
only thing is
day
that,
after tomorrow, Your Lordship.
once the records are produced, you can just
Yes.
make a list or index or just flag only what is necessary.
In the records, my lord, what I have seen, whatever records I have seen, my lord, the records, there is no livestock census, my lord. Because they are also not saying that livestock census has been carried out.
Detail has been supplied by
They are also not
veterinary
saying
department.
that SEC, State Executive Assessment Committee, has approved the demand. It's not their case also. It's not my case also that. So there, if the petitioner would have asserted no State Executive Committee under the State Disaster, they have approved the claim, etc. That is not the terms have not been fulfilled, my lord. I can place those records. There is no problem, my lord. But there is no dispute on these facts. Facts to that extent is that there is a minutes of meeting, there is an order, there is a flash flood. My case is that there is no camp. My officer says, no, we have set up the camp, my lord, and the orders have been placed without lives. So I can show all those things, my lord. But as far as that aspect is concerned, there is no dispute, my lord. And even for the sake of argument, my lord, also what my friend is saying, that I will place those records. I have no hesitation. Why should not, if your lordship have to satisfy your lordship concern?
And the record
First and foremost is
record would be relevant.
First and foremost is
record would be relevant from the commission secretary.
There has to be justification to the order.
Right.
You see, if it shocks the conscience of the court, the astronomical amount, so to say, is not justified, then
Exactly.
it is so.
Exactly.
You have a case.
For the purpose of calling for record, my lord, record from the commission secretary who filed the affidavit may be required. He's a sanctioning authority, he claims. Number two, the veterinary officer has filed a separate affidavit where he had admitted the entire contract. So the record from the veterinary from Garo Hills is required from the TC office.
My lord,
so
if he has admitted also, so there is a dispute. Now he has admitted. If admission is there by veterinary officer, tomorrow I admit that the state will pay 100 crore rupees, my lord. My admission will
argue when my argument will touch that one.
The peculiarity of this case is that on the array of respondents, there is a cross purpose. There is conflict. There is conflict even among you. Be that as it may, see, it doesn't matter. We'll have to look at what is justified and what is not.
Correct. And I'm armed with a Supreme Court judgment. Supreme Court made it very clear. The state cannot speak two voices in the court. Here,
if
my lord, two affidavits.
Cited that judgment in the counter, I would have
two voices.
I would have replied in the counter, my lord. If my I'll meet that argument also, but I need to go. It's not a two voice.
With due respect to London HG.
In the meantime, Mr. Sangesu, if there are authorities that we are relying on, you give him an advance copy.
We wish to share.
Have you also given him a copy of your
just received copy from
yes.
It's okay.
Yes, I have received. I have to.
You have received.
I have got on WhatsApp copy.
We are the one who always supply normally, but anyway, we have received. We have received.
Do that.
Yes, that's how we have received.
So how soon get you all the relevant records, please?
All the relevant records, my lord. Then my friend is saying because Mr. Abraham will be able to tell how much time you require.
From Garo Hills and the...
Yeah, 1 week's time is required, your lordship, because the record has to come from Garo Hills.
1 week's time? Today is 9.
Today is 9.
What I was submitting, my lord, if your lordship kindly permit me, lord, records will come, my lord. We will place the records, but that will have no bearing so far as the legal issues are concerned. Or factual issues are concerned.
That apart.
I will place that record, my lord, separately. May hear it and reserve the judgment, and we will place the record. We'll flag it. So that the matter will be, because after 1 week, your lordship, I also tend to forget the argument after a week or 10 days. And then again, so the lordship has heard the matter. What we can do is that my friend can conclude the argument. We will file the record with your lordship within a week. That way, also lordship.
No,
hearing will be concluded.
Let the records be, because if he refers
as your lordship,
if he refers to certain portion of the records, then that would be.
So your lordship,
that should have
because
been done
whatever he
earlier.
has referred to his in writ petition, he can't. The records are meant for your lordship, your lordship.
Exactly,
Whatever
because that is why
is meant for your lordship, not for the petitioner, my lord.
exactly
Petitioner
not for
can't, if
not
he
for
has
the petitioner, but according to his knowledge.
knowledge he has already reflected in the writ petition, my lord. What he can he say something more than
Government
what
cannot
he
shy
has
away
pleaded in
from
the writ
producing
petition, my lord.
records.
I'm
Shy away
producing
from
records,
producing
but I'm
records.
saying
Let
trying
them
to
produce,
conclude the
madam.
hearing. I'm trying
Otherwise,
to,
I'm
because
ready, my lord. I
we
can
have
conclude
all,
my hearing. I can conclude my submission. Lordship may call for the record. On their protection,
yes,
Lordship may give a short time to all both the parties. That also serve the purpose.
We'll call for records.
Yes, that is the best way. Call for records and go for final conclusive argument.
But in the
I have
mind of
already
in
argued
the
my
mind of the
point.
court, the matter is already 25
I've argued
on your side and 75 on their side.
It is a duty to fill up that one. But I'm ready, man. I'm ready, man.
So you try to
yes.
try to upset that balance.
Sure, my lord.
The public money cannot be squandered.
Right. Correct. I'll satisfy, my lord. So my friend is proposing on 1 week.
After 1 week, yes.
Mr. Kumar, AG, appearing for the state respondent, has concluded his argument on his argument. However, at this juncture, the learned senior counsel appearing for the petitioner has submitted that the relevant records pertaining to the facts and circumstances leading to the filing of this petition is required, and as such required for this court to look into the same and to be apprised of the factual aspect of the matter. It is therefore submitted that all the relevant records from various departments connected to the subject matter of this case be produced to this court.
My submission, your lordship, my submission is that I'm sorry, sir.
Yes,
my submission is that there is no requirement to produce the record because petitioner has asked for production of record. I say there is no requirement. I vehemently oppose, but I have no difficulty in placing the record below because on the asking of petitioner counsel, I can't put it.
Fine, I'll use your words then. The AG has responded by submitting that at this stage there is no requirement for production of any records as prayed for by the petitioner. However, the state would have no difficulty in production of the said records if so required. On consideration of the submission made for the satisfaction of this court, the said records are directed to be produced as prayed for. Accordingly, the state respondent is directed to produce the said record on the next date fix.
Well,
as prayed for, this is matter after 1 week.
Well, if Lordship may specify the respondent number 2, 3, and 5. These are the relevant respondents. Otherwise, they will produce only one record. That will not serve the purpose.
Relevant records. Note it down, Mr. Ram.
We will call, yes, from all the department, yes.
Veterinary,
yes.
Then
Deputy Commissioner and
Deputy
State
Commissioner
Disaster.
And State Disaster.
Yes.
Thank you.
Item number 14.
May it please your lordship. Lordship, this is a review petition wherein we've prayed for review or recall of the judgment order passed in a writ petition before this honorable court. Lordship, we had as per order dated 08, Lordship.
So you are going ahead with the hearing?
No, Lordship. There are some instructions that we had received today morning, Lordship. The managing committee, the governing body of the school, Lordship, as per order 808 of August 2023, Lordship, there was supposed to be an amicable solution that was supposed to be taken up, an attempt to solve between the parties, Lordship. We had received instructions today morning that the governing body had passed some resolutions, Lordship, and they have a material bearing in this case, Lordship.
What are those resolutions?
Lordship, we do not have the contents. We don't know the contents of the resolution passed. So I'm praying, Lordship, if...
Managing committee.
Lordship.
Is the managing committee also present?
No, madam. They are representing the managing committee.
Oh, you are representing the managing committee?
Lordship, we are representing the managing committee.
And moreover, my lord, before also they are telling that there is amicable solution. We are trying to solve this one, but they are not listening. Now they are coming for the plea that...
you are not aware of?
Yes, my lord. No, nothing, my lord.
Instructions were only received today morning, Lordship.
That is, they are only taking the time, please, sometime this, sometime that, like this only continue. Anyway, my lord, 1 week time may be given.
We'll give you 1 week. 1 week.
Yes, my lord. Positively, my lord.
Lordship.
Please do it.
Yes.
Otherwise, like Mr. Hajarika has said, it just goes on this, like this.
Yes.
You are referring to which order, Miss?
Lordship, 0808 of 2023, 8th August 2023.
Miss Letter Counsel Petitioner. Review petitioner has submitted that in deference to this court's order number dated 8/8/2023, whereby the parties are called upon to find an amicable solution to the dispute amongst them, the learned counsel has received instructions to the extent that the managing committee review petitioner has passed certain resolution in it. Do you know the date of the meeting?
Resolution for what, my lord?
Lordship, we've only received
What
the instructions
they have got? Resolutions taken for what?
That's what they said.
Yes.
Okay, we'll find that out. The line. Has made passed certain resolution or made certain decision, which will have a bearing on this instant petition. The details of such decision or resolution could not be ascertained immediately, and as such the Land Council has prayed that some time be given for the complete picture to be presented before this court. Mr. H. Hajarika, the counsel for the respondent, has made no objection to the prayer, but has reiterated that time and again the review petitioner has sought for time in this case, for which the matter has been delayed unnecessarily. Be that as it may, for the pursuit of justice, the court would allow all possible opportunity for the parties to present the case to their satisfaction. The review petitioner is to place whatever is necessary before this court on the next date fixed, failing which the matter will be finally heard. This is matter to 1 week.
Obliged, Lordship.
Item number 16.
This was the matter regarding the St. John's School, Lordship. So,
Lordship, actually, what I pleaded, Lordship, initially also, that section 7I of the like EPF Act, it says that if you have any, if they are aggrieved by the order of the
That is provision for appeal, section 75.
7I.
7I, sorry.
7I. So if they are aggrieved, and here it contains, according to their rejoinder also, according to their writ petitions also, they are disputing some facts also, which can be only decided through appeal, Lordship.
so Lordship, so hearing the matter, we can have it in the second half, or
Lordship is okay, I am there if second half is.
Yes, we can. We'll have it next week.
Next week.
On prepared by the parties, this is matter of the. What is the situation now?
Lordship, the situation is that the meeting has not really transpired much, but we are not disputing the amount. Only on 3 legal points we have placed 3 legal points. If those are not decided, or if it is seen that there is a dispute, then of course we have to allot.
What about the current dues?
No, current
Is
dues,
there
there is no
any current due?
difficulty with that.
No, if they are ready to pay the current dues, because the agitation happened because they are not ready to come up with the current. They are not ready before they are before the court. They are saying, but when they go to the office, they are saying that they are not ready to pay the current dues.
That was not for the specific period of those years.
Yes, that is not the subject matter here. In any case, it's my instruction that there is no as such.
No, they went to the meeting. The meeting happened, but when they set for when they come over for the meeting, they were not willing to pay the dues, which the
current
dues, whatever the due means, on what aspect we have passed the order.
Yes, that would refer to those years. I forgot the years. Could be 2012 or
that was between 1992 to 2008.
Yes.
In the current, as far as the current dues are concerned,
the dispute is with regard to that particular period.
Period.
Now, as far as the current dues, let's say
for this month,
21-22 or 22-23.
Yes, those are being there's
that
no
has been disbursed.
Yes, there is no.
I have no instruction because it happens actually. What happens, Lordship, to check the records. Unless and until financial year ends or something happens, then we are it is all online. Randomly we cannot go and log into some.
But you will have in your records you will have the
yes
result of
challans are submitted every month.
For example, you see, if you deposit money
yes
in a bank, the records will be there.
Yes.
You can just go through the statement.
Yes.
And this amount has been deposited on such date.
Yes.
So if they have deposited the dues for like again, for
the
example,
running dues,
not the defaulted months,
not
but
the current one.
The current only. Yes.
If that is
the month to month, what they are supposed to.
You're saying is done.
It's my instruction that there is no. We have not got anything from them also that we are not paying.
No, we have to find out from
not that you have to get to know from them whether you're paid or not.
If I may
it's for you to say whether you're paid or not.
Specifically, I have not taken a pointed thing, but as of now, my lord, it is my instruction that they are paying the running dues.
Okay, that is.
So we have to find out. I myself also specifically because actually what happens.
Find out.
Yeah.
Because if that is done, then you see we are only on the disputed period.
Not sure.
So that would not have too much of an impact as of now.
No, but it will impact because if the teachers retires, if any of the teacher retires during those tenure, then the EPF contribution of that teacher for the pension fund will.
That's beside the point. That's beside the point.
Yes, that will be.
We are not saying that the teachers are not to get the benefits of the scheme or not.
Yes.
That is beside the point. what we are saying is that as of date, if the petitioner is, diligently, complying with the provision, paying whatever is, their contribution, then
I have to find out that.
we'll take it up after puja then.
After
This is matter of the puja.
Much obliged. Just for the bank.
You are a bank.
Bank always comes at the last moment too.
But we always complacent with it. I'm not complacent, we are like on no side, Lordship, so we are here. Because you have made us come.
We were asking something about the, talking about the depositing, whether it was deposited or not.
So bank also we
bank
can.
Bank should know.
Bank should know. Whether the money is deposited or not.
Fine.
Obliged, Lordship.